Thank you everyone for joining us this lunchtime. I'm Daniella Gilbert, an employment barrister at Pump Court Chambers. I'm joined today by the lovely Siân Beaven, who is one of the newer members of our employment team. If anyone has any questions during the presentation, we've got quite a lot of ground to cover, but we will try and answer some at the end if we have time. If you have questions, please just put them in the chat box below, and we will keep an eye on that during the course of the seminar. Also, after the seminar, our excellent marketing manager, Sean, is going to send the slides to you all via email, so you'll have them as well. So let's get started. I will share my screen. And away we go. Right. So today's No Jab, No Job hot topic seminar. There's three key areas that we're going to cover. Can employees be required to have the COVID vaccine? What issues might arise if they are required to do so? And is there any difference between existing employees and new recruits? So those are three key areas. First off, in general terms, can employees be required to have the vaccine? Currently, there's no legislation that would permit or require a mandatory vaccine. However, a number of you will probably be aware of the recent government consultation response, which the outcome of which is essentially that all Care Quality Commission regulated service providers who provide accommodation for those who require nursing or personal care will only be able to permit entry into those premises to those who are vaccinated or exempt from vaccination. And as we see from the response, it's not just those employed in care homes themselves. So it applies indoors only, but anyone who is coming inside is also going to be subject to that requirement. So for example, tradespeople coming into care homes. So if it's an employer whose predominant business is placing trade people into those sorts of institutions, then they're going to have to be alert to those changes when they do come in, which is proposed later this year. Why might employers want to put in place this sort of policy? Well, employers are subject to a number of duties. There's obviously the common law duty to take reasonable care for the safety of staff and others who are foreseeably affected by employers' actions, and there's a duty to provide a safe system of work. There's also the duties under the Health and Safety at Work Act. So Section 2 is the duty to ensure that workers are safe, and Section 3 to conduct their undertaking in such a way so as to ensure that, as far as reasonably practicable, persons not in their employment but affected thereby are not exposed to risk. So that's going to be really anyone who's going to be coming into close contact with an employer's employees, people who might be coming into employers' premises, for example. So there's those duties to be aware of. In the context of COVID-19, this might mean putting in measures for social distancing, cleaning, face covering, and also potentially regular testing. What's required depends on the circumstances, obviously, and some may be considered more of a requirement, some good practice. So all things to bear in mind. What are the employees' duties? Well, first of all, there's the duty to cooperate, and that includes in maintaining the safe system of work. So that would be a duty to comply with the reasonable measures that are imposed by an employer. So many of you will probably have heard of the Kent Foods case earlier this year, in which it was held that an employee who refused to wear his face mask was fairly dismissed. There's also the duty to comply with reasonable and lawful instructions of the employer. What's reasonable, obviously, is going to depend on the nature of the job, and what's lawful is going to depend on the nature of the instruction. And I'll come to that in a moment. So that's the employee's duties. What are their rights? Well, they have the right, obviously, to be provided with a safe system of work. And there is a corresponding contractual obligation that comes into play there. They also have the right to refuse medical treatment. And that is a right that every adult has prima facie, and the authority for that is RETI, among others. And the point to emphasise there is that is so, notwithstanding that there's a very strong public interest in preserving the life and health of all citizens. Naturally, given all citizens' Article 8 rights under the European Convention of Human Rights. So even where the public health is at stake, no one can be compelled to have the vaccination. We have the Public Health Control of Diseases Act 1984. There's section 45C, which is the health protection regulations relating to domestic. Now, what that section says is that it permits the making of regulations that make provisions for the purposes of preventing, protecting against, controlling a public health response. And that includes the spread of infection. However, that's subject to section 45E, which specifically provides that those provisions may not include requiring a person to undergo medical treatment. And the subsection therein specifically includes vaccination. So whilst we have two significant issues there, Article 8 rights and the rights under the Public Health Control of Diseases Act. So the natural conclusion, obviously, is that employees cannot be forced to have the vaccine, but can they be disadvantaged by their choice not to have it? And can an employer impose a blanket vaccination policy? Well, one of the most obvious issues that arises there is the potential for discrimination, in particular under Section 19 of the Equality Act, so indirect discrimination. And the reason that's so significant is there is a clear disparity in vaccine hesitancy. And I'll set out some statistics here from the most recent Office of National Statistics report. So whilst 96% of all adults reported positive sentiment towards the vaccine, there was greater hesitancy amongst some ethnic minority groups. 20% of Black or Black British adults reported hesitancy. There was also greater hesitancy amongst certain religions. So 11% of adults identifying as Muslim or other reported hesitancy, as compared with 5% of adults who identify as Christian and 2% who identify as Hindu. There was also, interestingly, no significant disparity between men and women, but one point to be aware of is that of those women who were hesitant, 31% cited fertility as their reason for refusal. So there's potential indirect discrimination issues for any blanket policy. And what we need to be aware of is that's across all protected characteristics. So there's the positive sentiment disparity, there's potential medical barriers, disability. There's also issues with availability, less so now, given that the rollout has been so successful and is fairly available to most age groups. But of course, those who are younger may not have had both doses yet. So any policy must be capable of objective justification and must be framed carefully with appropriate exceptions to ensure that it's not going to be indirectly discriminatory. What do we need to consider when we're talking about objective justification? Well, it's going to be fact specific, and it's going to depend on the job and the nature of the employer. So, for example, the nature of work, the need to protect colleagues and members of the public. So what one needs to be thinking about there is whether employees are in regular close contact with each other, with the public, with vulnerable individuals. They're also going to want to consider a client's requirements. So does the business need to respond to a particular client's or several clients' requirements? What about future legislation? Is that going to impact? Is that going to impact on objective justification? Have alternatives been considered, generally or on a case-by-case basis? So, for example, could it be a reasonable adjustment to, say, permit an employee to have lateral flow tests regularly rather than be vaccinated? What cost is that going to impose on the employer? And is it reasonable for the employer to incur that cost rather than have in place a discriminatory policy? So those are all general considerations that are going to apply to all protected characteristics under indirect. But I'd like to focus on two, and then I'll hand over to Siân for a third, a particular area of interest with regards to potential for discrimination. And the first I'm going to deal with is pregnancy. Now, the current guidance from Public Health England is that pregnant women should be offered the vaccine at the same time as people of the same age or risk group, and that vaccines can be received while breastfeeding. But 19% of women were hesitant because of the concerns of the effect on their baby. So that's potentially giving scope for an indirect sex discrimination claim. But we've also got Section 18 of the Equality Act, which says that a woman must not be subjected to unfavourable treatment because of pregnancy or an illness resulting from pregnancy during the protected period. So if, for example, a woman suffers an illness that results from her pregnancy, which means she is less able to have the vaccine, then she cannot be discriminated against during the protected period on the basis of that reason. Now, the protected period is going to end either when she returns to work or at the end of the extended maternity leave. So then the employer may need to consider giving some time in between that for her to have that vaccine. These are all things that need to be considered. The next specific is disability, and in particular, Section 15 of the Equality Act, unfavourable treatment because of something arising as a result of disability. Now, unlike Section 18, Section 15 discrimination is capable of objective justification. So what, for example, is an employer to do if an employee suffers, say, from anxiety, and as a result of that anxiety, they have a severe fear of needles? The employee could argue that that fear is something that arises as a result of their disability. And so if they are subjected to unfavourable treatment because they refuse the vaccine, that would be Section 15 discrimination. In those circumstances, again, an employer is going to need to consider what alternatives there are to imposing this policy, either generally or on a case-by-case basis for particular employees. So I'm now going to turn to Siân for the next interesting aspect, which is in particular religion and belief, and are those who are anti-vaccine covered by the Equality Act? So,
switch our share screens, just one moment. We'll stop others. Yes, I would like to continue, please. And hopefully, just like magic, we will have switched screens and now I'll be sharing. So this is a consideration that the courts may have to grapple with in the future, that as well as those, for example, that may have medical exemptions or religious objections from having the vaccine, there are, as we all know from the media, a significant minority of people that have been dubbed the anti-vaxxers, who object to the COVID vaccine, and this may be for a variety of reasons, including concerns about the safety of the vaccine due to its rapid development, and perhaps even some that will subscribe to, for a better word, conspiracy theories that the vaccine is some sort of international ploy or in other ways dangerous. Now, whilst many employers, of course, recognise that any vaccine policies of the present or future would require careful drafting so as not to discriminate against those who cannot be vaccinated due to protective characteristics under the Equality Act, the anti-vaxxers present a slightly more unique challenge as to whether any of those beliefs surrounding their concerns over this particular vaccine could be protected under anti-discrimination law. And to examine this, we must first consider what amounts to a recognised belief in law and whether skepticism to the vaccine could come under that. Effectively, this is a definition that has been expanded far beyond what is simply recognised and established religious faiths to encompass wider philosophical and moral beliefs, providing they fulfill certain criteria. As you'll see from your sides, the case of Casamajana and the League Against Cruel Sports dealt with this issue quite comprehensively with regard to ethical veganism and whether this could amount to a belief in law. The answer on the facts of that case was that it could, as it was said to fulfill the following criteria. Effectively, with regard to the notion of an anti-vaxxer, in order to get home before a tribunal on whether this amounts to a belief, these criteria would also have to be met. The first might on the face of it appear fairly simple, that it's genuinely held. One would certainly hope that for whatever reason behind the concerns that many anti-vaxxers have, it is likely that they genuinely feel that way and genuinely have those concerns. With regard to the second criterion, this is rather more difficult. The fact that concerns over vaccines may well be based on the information that is presently available, and therefore this is likely to be a difficult hurdle for somebody who claimed to be an anti-vaxxer to overcome. Vaccines of differing types, not necessarily that for COVID-19, have been around, of course, for many decades, and there have been controversial elements to vaccines before, such as the MMR crisis. Over time, it's thought that the objections surrounding, for example, the speed and development of this vaccine are likely to diminish, suggesting that these objections currently held by some people are likely to be opinions on the safety of that development, and, if you will, an unwillingness to be, quote, a guinea pig. It's possible also that any attempt to claim an anti-vaxxer status as a belief could be undermined factually with reference to willingness of the individual to undertake other vaccines or other forms of modern medicine. Of course, if a hypothetical claimant had always been someone who had serious objections to modern medicine and medical interventions and had rejected other such interventions, on the facts they may be able to demonstrate that their objections went beyond a mere opinion or viewpoint. But it's difficult to conceive of many such people who had refused large numbers of other medical interventions, perhaps those even that they were subjected to in childhood, and because they had a strongly held belief against it. It's likely that those type of people would be incredibly rare, and of course would still have to be able to demonstrate that this was both genuinely held and beyond a viewpoint. But for those that have been taken in by the conspiracy theories, so to speak, surrounding microchipping, altering of DNA, etc., that have no scientific basis attached to them, I would suggest that they would be likely to have an even more difficult time demonstrating that this would amount to a belief. Certainly, because of course the final criteria states that it must be worthy of respect within a democratic society. And of course, many of these theories that people do hold dear appear to have no justification from the scientific community at all. So whilst it cannot be said that there is absolutely no way in which an anti-vaxxer could succeed in showing that this amounted to a belief under the Equality Act, it's unlikely to be held as such. There are a wide variety of reasons why someone may be vaccine hesitant or vaccine skeptic. And it was for this same reason that the Employment Tribunal has previously refused to recognise vegetarianism as a philosophical belief in that same way. Someone, of course, who was skeptic of all vaccines may be more likely to show if, of course, the individual was able to explain why this was a consistent and cogent belief. But of course, this has already been mentioned by Daniella, the more likely line of legal challenge would surely come from a minority ethnic or religious group, which have been shown to be statistically more vaccine hesitant. And we know from those statistics that there are certain community groups who are more likely to refuse vaccination. And therefore, there is the potential, of course, that a vaccine mandatory policy policy could be seen as indirectly discriminatory towards those from those hesitant communities. I can move on. So moving on to an almost entirely different topic now, but certainly this is the way that the debate, if you will, has developed in recent times, obviously coming to a point now whereby there is hope that restrictions may be lifted within their entirety on the 19th of July. Were that to be the case, of course, we're yet to understand what the government's position would be on the work from home guidance, but certainly there is wider scope to have a greater variety of workplaces open and a willingness amongst some employers, of course, to have their workforce return to the office or to the ordinary place of work as opposed to working from home regularly. That therefore has raised the question as to whether employers may seek to mandate vaccination status as a condition of returning from working from home to working in the office or the site of work. Of course, as has already been mentioned by Daniella, the employers are, of course, bound by the Health and Safety at Work Act and have a duty to ensure, as far as reasonably practicable, the health, safety and welfare of their employees when they are at work. And of course, customer-facing businesses, that extends to the customers that they encounter as well. Now, it's already been mentioned, but the case of Cubilius and Kent Foods obviously looked at the fair dismissal of an individual who refused to engage with the required PPE on site. However, the idea of mandating a vaccine to enter a site or enter an office is much more problematic to enforce. People, as we know, have the right to refuse medical treatment, and this is a far more intrusive requirement than simply being required to wear temporary protective equipment such as a mask, and would therefore require far greater justification. Of course, the position with the unions on this matter has been highly critical of any suggestion of a no jab, no job policy, or certainly now perhaps a no jab restriction as to your working rights policy. And there have been unions that have asked the government to consider making them illegal. This criticism is largely based on the suggestion that policies create a divisive atmosphere and aimed at workers and seeks to create a worker blaming culture when some employers may fail to put into place sufficient protections in their workplaces in order to keep them COVID secure. Of course, the uptake of the vaccine does not suggest that those who have been vaccinated are incapable of passing on infections to others, and therefore the obligations on the part of the employers to risk assess their premises and ensure, as far as reasonably practicable, a safe working environment will continue and remain in place for some time. Requiring a vaccine from employees does not amount to a fix-all, and nor would it offset the duty of the employer to maintain a COVID-safe office. Certainly, any attempt to exclude unvaccinated employees from some or all of their work premises is likely to be open to legal challenge, largely, of course, depending on the wording or the specific wording of an employment contract. Because if you imagine, of course, employment contracts differ from employer to employer, and indeed from different types of work. But certainly if a workplace is specified as a designated office or other venue within the terms of the contract, then assuming that the venue is open and permitted to be open by law, then an employer would likely be able to enforce their contractual rights to enter their place of work as defined. And of course, therefore, again, this is likely to become quite fact specific as to the terms of individual employment contracts. Now, of course, I know Daniella is to address a little further on this point, but employers considering imposing new contract clauses, mandating this as a precondition to returning to the office or designated workplace are also likely to be met with some challenge. And of course, there are obvious issues for restricting employment rights on the basis of vaccine status, namely, the timing of such a policy. Would one dose be sufficient, or would an employee be required to be fully vaccinated before being permitted re-entry into the office or site? And this, as we know, has the potential to be discriminatory, particularly on the basis of age, because as many will be aware, those in the younger age groups, whilst being offered their first vaccine, are not yet at a stage where many will have been able to take up an offer for a second dose vaccine. And therefore, it would almost certainly result in discrimination claims on the basis of age. Of course, there are also pragmatic alternatives, such as requiring regular testing of employees who wish to come back into the office. Of course, there may be many who would rather continue working from home or have some kind of hybrid working, but that would obviously avoid the need to mandate vaccination, and certainly that would be problematic to do so, or to attempt to do so, before everyone had had at least the opportunity to undertake both doses. Now, when considering the drafting of employment contract terms, the next issue to consider will be how these are to be imposed on both existing and prospective employees. And so I'm now going to bounce back to Daniella and her screen so that she can continue with the presentation.
I was just going to say that we're almost out of time, I think, so I'm going to whiz through what I've got very quickly, as quick as I can. If anyone has any questions, you can email us afterwards. The information will be on the slides anyway. So whether or not vaccination can be required of existing employees, either generally or for them coming back into work, it's going to depend on the terms of the existing contract and the scope. So scope of any term relating to issuing instructions to employees, how widely is that drafted? What about terms that relate to complying with employers' policies, such as a new policy for vaccination? How widely is that drafted? The scope of complying with legislation, foreign and domestic. Foreign might come in because you might have employees who are working abroad, and the legislation abroad, foreign requirements may change, particularly in terms of entry requirements, if they have a term that requires them to be available for travel, or have the right documents for travel, or comply with any requirements for travel. That might be a term that, although not initially drafted to cover this, may, and I say may, be wide enough to impose that policy. Where the terms don't fulfill that requirement, any attempt to change it unilaterally is likely to, particularly given how significant a requirement it is, may very well amount to a constructive dismissal. So we're then in the realms of whether the employer can justify that, for example, by way of some other substantial reason. There's queries about that. The Office of National Statistics suggests that those who become infected post-vaccination less likely to have symptoms and less likely to have a high viral load, which suggests that they're less likely to pass it on. So there are some benefits to it, but are they significant enough? And are there any alternatives? What about it being refusal being a reason for disciplining or dismissing an employee, either for conduct or some other substantial reason? Again, it's all going to be very fact specific, and I would suggest that an employer who doesn't really go through with the employee why they are refusing, whether it's a discriminatory reason, whether it's some other significant reason, an employer who doesn't consider alternatives such as lateral flow testing may well not be conducting and behaving reasonably if they dismiss in those circumstances. New employees, it's slightly different. There's the freedom to contract on the manner that you wish, but employers should bear in mind Section 39 of the Equality Act and any discriminatory potential for those policies and terms. So in conclusion, the vaccine requirement may be permissible, but it will depend on its own facts, each case. Different considerations apply to existing employees and new recruits. The potential for discrimination is a common element amongst all topics under this, and careful consideration needs to be given to any policy which must be capable of objective justification. All right, we just about managed to get there. We're 1 minute over. I'm sorry we don't have any time for questions, but as I said, If you do have any, then feel free to drop us an email. Thanks for joining.